Okay, we're now on the docket for Monday morning civil docket for July 26, 2021. We are on the record. Mr. McInnes, what do you have?
Good morning, Judge. I'm here on number 35 on the docket, which is Gem Enterprises LLC versus WBL SPE III, LLC, cause number CL 21-1711-I. Mr. James Cuellar is opposing counsel, and I see him online here, Judge. Judge, this is status, and our status is we are presently awaiting a mediation to occur on August the 17th at 2 p.m. with Alfred Denham. So once we have that mediation, we will report back to the court whether it succeeds or not.
Okay, that's on August the 17th.
That's correct, Judge.
Okay, so do you want your status date right after on the 25th, or do you want a little bit longer than that?
I'm okay either way, Judge.
Okay, just so that we know what we'll be doing, I'll have you come back on August the 25th at 9:30 and let me know how that mediation went.
Sounds good.
Okay, Judge, we have to go further. May we be excused?
You certainly may.
Have a great day,
Thank you.
Judge.
Thank you, gentlemen. Okay, Judge Cantu?
Good morning, Your Honor. Rolando
Good morning.
Cantu. I'm here on number 28 on your docket. I've been in contact with Mr. Montalvo's office this morning, Mr. Marcos Montalvo, and this is a status, Your Honor. And I believe last time we requested a DCC, and the court was not providing DCCs at that time. So at this time, I guess we would want to, confer with counsel and see if we can file a motion for DCC or whatever the court wishes, or if we can come back on a status, whatever the court wishes.
Okay, so then you've already worked up this case and you're ready for trial.
We would like a trial date, yes.
Okay. Okay, well, tomorrow I think we're getting more direction after the Board of Judges meeting as to how we're going to be handling
I know.
the jury pools and what we're doing next. So what I'll do is what I've been doing is setting the latest status that I have, which is September the 29th.
Very well.
And at that time, I should be prepared to see what our trial dockets will start looking like.
Very well, Your Honor.
Okay, so if you'll just let them know, come back on September 29th at 9:30.
Very well, Your Honor. Thank you very much. And you have a great day and stay safe.
Thank you, likewise.
Bye-bye.
Okay, Attorney Bobby Garcia.
Good morning, Your Honor. Bobby Garcia here for the plaintiff. We're number 31 on the docket. I saw Nick Denzer that was opposing counsel on, and Rogelio Solis was I believe on here also. Your Honor, this is for a status hearing, and we have not completed even written discovery yet. The plaintiff intervener filed a motion for status just on the intervention. There's been a general denial that has been sent in response to the counterclaim that has been sent. But basically, written discovery needs to be completed. We need to take some depositions and then proceed, to mediation, see if we can get this thing settled, and then, then thereafter plan. Okay, Mr. Denzer, do you have anything to add?
No, Judge. I represent Ms. Arevalo in her claim as a defendant. But yeah, what Mr. Garcia said is true. We need to get some depositions set up and still do some written discovery.
Okay, and you said that Mr. Solis was also on this case?
Yes, ma'am. He had filed an intervention, on this, and it was an intervention to file a counterclaim.
Okay, and was he making an appearance today?
He's supposed to. He had the motion. There was a motion for status here and a motion for status on the intervention. And I think that is moot because there's been a general denial that has been, submitted and filed.
Okay, so then, and how much time are you looking at? You're just, so then you're just starting your discovery process then?
Yes, ma'am. We've gotten written discovery. There's a few things that we've got to get straightened out with a written discovery. And this intervention was a gaffe that we had to just take care of. And that did impede the discovery a little bit. But I think right now we're ready to go.
Okay, so then would you have a good status report in October? Or is that too far out?
No, ma'am. I think October would be just absolutely fine.
Okay, that way you can continue working up your discovery and see if maybe you can attend mediation prior to that time. And then you can come back on October the 27th. And let me know what's been happening.
Yes, ma'am.
Okay,
Thank you, Judge.
Yes, Your Honor. Thank you
Okay,
very
thank you.
much.
y'all have a good
Have a
day.
good morning.
You too.
Yes, ma'am.
Thank you. Okay, Ms. Portis?
Yes, Your Honor. Sorry, just trying to get muted off. I am here on 3 cases this morning. The first one is on page 4. It's number 16, One Main Financial versus Rodriguez.
Okay,
This one we're set for a motion for default judgment, but I do not believe we have a business records affidavit on file, either with the motion or with the original petition. So
Okay,
that's the
so-
court to,
reset that.
yes, Your Honor.
How much time do you need?
I think 60 days.
Okay.
Thank you.
Then the September 29th.
Thank you. At 9:30?
Yes, ma'am.
Okay. And the next one is number 7 on page 2. Portfolio recovery versus Sabeda Rosales.
Okay, that is CL 154065-I. And what is your announcement, Counselor?
Your Honor, we filed a motion for summary judgment on June 21st of 2021. There's been no response to it, so I ask the court to proceed with that summary judgment.
Good morning,
Okay.
Ms. Cordes. How are you?
Sorry, Judge, I just had a late
Okay,
check-in.
okay, Mr. Damian, can you please call out the name Sabeda Rosales 3 times?
Yes, ma'am. Sabeda Rosales. Sabeda Rosales. Sabeda Rosales.
Okay, Ms. Portis, can you give me the date of service, please?
Yes, Your Honor. Defendant was served on January 12th of 2016.
And she filed an answer on what date?
She filed an answer on January 15th of 2016.
Okay. Okay, Ms. Portis, you may proceed.
Yes, Your Honor. This was originally a GE Capital card, GC Penny card ending in account number 0062. We're asking for judgment in the amount of $1,327.10. Attached to the motion for summary judgment are business records affidavit, account statements, and transfer documents from the original creditor to portfolio recovery. Ask the court to enter that in as evidence at this time.
Okay, that'll be admitted.
Yes, Your Honor. And so account was opened back on April 3rd of 2021. Last payment was made on July 2nd of 2012. Suit was filed on November 20th of 2015. Defendant has been, sorry.
Okay, I'm sorry, did you get cut off or?
No, I thought you were asking me a question. I'm sorry.
No.
Sorry, a defendant has answered. They have not responded to the motion, so we'd ask for a court to grant judgment as proposed in the attached proposed order to the motion.
Okay, so that order has already been on file with the court?
Yes, Your Honor.
Okay, Then the court will take judicial notice of all the documents in the court's file, specifically that no response was filed to your motion for summary judgment. And the required notices did go out to the defendant. So if you'll, I'll have the order granting forwarded to my queue and I'll sign off for that.
Thank you, Your Honor. And then
Okay.
on the last one I have is number 10 on page 3. And we filed a motion for default judgment.
Okay, what number is that on the court docket?
It's number 10 on page 3, portfolio recovery versus Rosalinda Garcia.
Okay, that is CL 184094-I. And Mr. Damian, please call out Rosalinda Garcia's name 3 times.
Yes, ma'am. Rosalinda Garcia, Rosalinda V. Garcia, Rosalinda Garcia.
Okay, her name has been called out 3 times and no response. You may proceed.
Yes, Your Honor. Ask the court to take judicial notice of the motion for default judgment on file and enter into evidence its attachments. I'm showing that in the business records affidavit attached to the motion that the defendant opened an account on March 27th of 2006. The last payment was made on August 13th of 2015. Suit was filed on August 20th of 2018. Defendant was served on August 28th of 2018, and they've not answered or responded to our motion for default judgment. There should be a proposed order attached to that motion. We're asking for $1,382.56 cost of court and post-judgment interest.
Okay, the court will take judicial notice of all the documents in the court's file and will grant the relief requested by the plaintiff. And I'll have that forwarded to my queue as well.
Thank you, Your Honor. That's all I have for today. May I be excused?
You certainly may.
Thank you, Judge.
Thank you. Okay, Attorney Travis Benz.
Good morning, Your Honor. Travis Benz. I'm here on cause number CL-160317.
Okay, what number is that on the court's docket, sir?
Unfortunately, Your Honor, I don't have that number, and I was going to send a chat, but I was afraid it was going to go to you directly, and I had no desire to get in that kind of trouble with the court.
Okay, what was the number again?
CL-16-0317.
Okay, that's number 8 on the court's docket. Midland Funding versus Christina Garza.
Your Honor, I apologize for not having that number. With the court's permission, Your Honor, this is my client filed a motion for default. We respectfully request the court take judicial notice any and all documents in the court's file. All conditions precedent have been met. Your Honor, this is a case in which a suit was filed on November 21st, 2016. The date or the defendant was in fact served on February 26, 2016. There is no answer on file. This matter is ripe for a default judgment, Your Honor.
Okay, let me have the defendant's name called out 3 times.
Cristina Garza, Cristina Garza, Cristina Garza.
Okay, Mr. Benz, the name being called out 3 times and no response. The court will take judicial notice of all the documents in the court's file. Specifically that the defendant did not file an answer and that all the prerequisites were met prior to today's hearing. And we'll grant the relief that was requested. And do you have an order on file?
Yes, Your Honor. If it has been e-filed, if for some reason it's not in the court's queue, I'll ensure that it's done before the end of the day, Your Honor.
Okay, then I'll ask for that order to be forwarded to my queue, sir.
Your Honor, that concludes my business for this honorable court. May I be excused?
You certainly may.
Thank you, Judge.
Thank you. Okay, Attorney Lucia Thompson.
Yes, Your Honor. Lucy Thompson here, number 36 on the court's docket. Pete Espinosa is opposing counsel. I don't see him yet.
Oh,
My
yes.
client is, oh, sorry.
Okay, Mr. Espinosa's office called in and said that he was in a contested matter in one of the other courts and would be a while.
Okay.
I
Would
don't
you
know.
like me to log back in or give you my status? How would the court like to do that?
Well, you all were going to be set for a bench trial. Is that going to move forward?
I don't see how it does, Your Honor. The government, the debt that, the money that is owed to the government is still owed and outstanding, and the criminal charges, the criminal case is set for trial next month
Okay.
after the bench trial setting.
Okay. And I don't want to lose track of you all. You said that there's a trial setting. What is that trial setting?
I believe it's August 24th, Your Honor.
Okay. Why don't you come back on September the 29th and let's see if once everything has passed with that trial, to see if even that trial was had. And then we can see how we'll proceed from there.
We will do so, Your Honor. Thank you.
Okay. All right.
May we be excused?
You certainly may.
Thank you.
Thank you. Okay, Attorney Barry Ray.
Good morning, Your Honor. Barry Ray here for State Farm on Kate. It's number 30 on your docket. Reyna versus State Farm.
Okay, that is CO 20-2815-I, Daisy Reyna et al. Versus Antonio Quintanilla et al. And what is your announcement, Counselor?
Well, it's just a status conference, and I believe I saw David.
I'm here, Your Honor. Good morning.
Okay.
Okay, good morning, Mr. Solis.
Just a status conference, really, Your Honor. We have depositions of the plaintiff scheduled on September 2nd, and then after that, most likely we will schedule the case for mediation.
Okay,
Your Honor, good morning. Roger Garcia for defendant Antonio Quintanilla, if I may.
yes, sir.
Your Honor, this is as a backdrop. This lawsuit was actually a friendly suit at its inception. It was initially filed for a minor prove-up. We have the Honorable Regina Richardson as the ad litem, and we were in fact scheduled for a friendly suit final hearing. Then the petition was amended to include a first-party UIM claim. That's where Mr. Barry Ray came in. But as far as Mr. Quintanilla, we are ready to proceed with our minor prove-up hearing. I'm not sure how the court would want to entertain that. If you would prefer for us to wait to see if there's resolution with the first-party claim as well. But Mr. Solis and I have had this conversation. I'm willing to deposit the entire settlement funds into the court's registry in order to have Mr. Quintanilla's feature of this lawsuit dealt with.
Okay, so if you all are in agreement that it's not going to affect the other part of the case in any way, we can proceed with a friendly suit hearing on what is applicable to the friendly suit. Not today. You can file an order setting hearing on that friendly suit hearing if you all are in agreement with that. But Mr. Ray, what is your position with respect to that friendly suit hearing?
Oh, Your Honor, I don't really think it affects me. It's just, quite frankly, I wasn't aware of that or had forgotten about it, I guess. I thought the plaintiff's claims against the other party had already been resolved and completed. But I guess they have been resolved. I guess perhaps they just hadn't gotten the court's approval of the minor settlements. I wasn't aware of that.
Okay, well then, with respect to that, just file an order setting hearing on that. Make sure that you CC everyone, including Ms. Richardson, and then we'll get that set for you as soon as possible.
Your Honor, if I may
Thank you.
interject real quick, we're not ready as far as the minors in a position to disperse the funds yet because the case is still ongoing. I have no objection if we prove it up and deposit the funds into the registry until they can be dispersed. But we're not in a position right now to provide Mr. Garcia the information as to how the funds will be distributed, how much is going to go into the registry, how much is going to be for medical providers and so forth. So I have no objection depositing the funds into the registry of the court. We're just not ready to disperse. And we're not going to be ready to disperse until this UIM first party case is resolved. And to provide a little bit more background, although this case did settle for limits, this was a 3-vehicle accident with more than just my clients involved. So because of that, my clients not received the full policy limits. It was dispersed or divided up pro rata. So that's why we had this UIM case pending. But I have no objection.
Thank you. And I was going to say, I'm sorry, Mr. Solis, in the interest of full disclosure, Your Honor, that's the conversation that Mr. Solis and I had. I have not had a conversation with Mr. Ray. What I was going to consider is contacting both, maybe have a conference call. And if it's in the best interest that we wait in order for that mediation to take place that was referenced earlier, and then just have one final hearing in one fell swoop, that may be the best scheduling procedure to take place, to consider. And that way, Ms. Richardson would only have to show up for one hearing. So if the court will allow me, I'll contact both Mr. Ray and Mr. Solis to see if we can reach an agreement and accommodate.
That's fine with me. I mean, like I said, I'm willing to give you the time for the hearing that you need, but if that sounds to be much more efficient to me, but that's just me. So it's however you gentlemen want to handle your case is fine with me. So what we'll do is, since you're just scheduling depositions and then you need to see what position you're in after that with discovery to do mediation, I'm going to have you come back. I'm going to have you come back on October the 13th. And let's see where you're at that point.
Is that at 9:30 also? Your Honor?
Yes, sir. Yes, sir. Okay. Anything else?
Your Honor, I have one additional case, but
Okay.
nothing else on this case.
Okay.
Your Honor, that's all I have before your honorable court. May I be excused?
You certainly may.
Same here,
Thank
Your
you,
Honor.
Judge.
Okay.
The
Mr.
other,
Solis,
the
we're
other
gonna
case I have is number 29 on your docket, Your Honor. It's also a status hearing case. I know somebody from, I do not know who is handling the case on behalf of the defendants. I know Mr. Irwin is the attorney assigned who I've been dealing with, but I don't know who from his office is going to be attending today.
Okay, that's CL 20-2647-I, Hector Elizondo versus State Farm Mutual Auto Insurance Company.
Your Honor, Renee Borneo is here on behalf of the defendants.
Okay, and what is your announcement, counselors?
Your Honor, looking at the file, this case was transferred from Court 5. We're currently scheduled for trial on 9/13/21. I'm going to go ahead and presume that trial is going to be postponed so I can update my calendar. Depositions have not been taken. Since this is a first party case, I'm not going to be deposing the defendant in this case. It's also a State Farm case. So as such, I'm ready to proceed to trial. Obviously, you're not giving out trial dates. If you could schedule this for mediation in the next 60 days or less, so we can have a determination if the case is going to be resolved or not, that would be my only request.
Okay, and do you all have a mediator that you can agree to?
Your Honor, before we get to that, we do plan on taking the deposition of plaintiff in this matter prior to that. So if we do schedule a date for mediation, I would request that at least 60 days be given so we can get the deposition done of plaintiff and then go to mediation after that.
And Your Honor, I have no problem with presenting my client for deposition, but this case was filed well over a year ago. Depositions haven't happened yet. I understand they want to move forward with depositions, but we just can't sit back and wait for them to decide to depose our client and then schedule mediation. If you can give us a deadline for mediation, then I'm sure that they'll get the deposition on time rather than just waiting for them to request a deposition of our client. So that's why I'm requesting the mediation deadline.
Well, it sounds like both of you are in agreement with mediating within 60 days, which I don't have a problem ordering. Will you all have an issue in agreeing to a mediator?
I don't suspect we will, Your Honor.
Okay.
And neither does the defense, Your Honor.
Okay, so then agree to a mediator, and if you can't, then the court will assist you with the mediation. With assigning the mediator.
So if you're giving out the date of 10/13/21. Can that be the status hearing and the mediation deadline?
Okay, well, that's not gonna, well, yeah, that'll give you 60 days. Yes, we can do that. So come back on that date as well, on October 13th.
Your Honor, that's all I have. Thank you very much.
Okay, anything else?
No, Your Honor, that's also the only case I have on the docket today.
Okay, thank you, gentlemen. Have a good day.
Thank you very much.
Have a good week, Your Honor. Bye-bye.
Okay, Attorney Karina de Luna?
Good morning, Your Honor. I have number 32 on the court's docket. Opposing counsel is Mr. Fernando Lopez. He's not on, but I did talk with him. We did mediate this case. We were unable to settle the case. However, we are pretty close. I know the court is not giving out trial dates right now, so maybe we can just get another status.
Okay. And so, how much time do you think you'll need if you all are close to settlement, just so that you can give me a good status report? Oh. Okay. The screen froze. Is it just me or did I freeze?
Your Honor,
Okay.
it does appear that her screen has
Screen froze.
frozen.
Okay.
I'm sure, okay, here she's back again.
Oh, there. Oh, no.
Oh, spoke too soon. Apologies, Your Honor.
Oh, she's probably gonna come back in. Okay,
Yeah,
I'll call her as soon as she comes back in. Okay, Ms. Martinez.
Sorry, Judge.
Oh,
I
there
think
you
I-
are. Okay.
I think it froze.
Yes. Okay, so how much time do you think you'll need?
The September or the October date would be fine, Judge.
Okay, well, I'll give you till October the 13th. And that way you can continue with your discovery and see if it's enough for you all to settle the matter. And besides, by then, if you do need to go to trial, then I should be able to provide you a date for a DCC.
Thank you, Your Honor. That's all I have before this court. May I be excused?
You certainly may, ma'am.
Thank you. Have a good day.
Thank you. Likewise. Okay, Attorney Consuelito Martinez, please.
Thank you, Your Honor. Consuelito Martinez, on behalf of Ashley Nicole Ramirez, we're number 23 on the docket. The style of the case is Santana, Garcia, etc. versus Ashley Nicole Ramirez. I do believe opposing counsel Michael Pruneda is on this call. We're here today just to ask for a little bit of help, Your Honor. We've been trying to schedule the deposition of the plaintiff, Monday through Friday. We'll even start at 10:30. We can be a couple of months in the future, but we just need a date certain for when we can have this deposition, because we're at that point where we're almost done with discovery. Like very, we just need the depositions. We can go to mediation and hopefully resolve the case. I mean, that's really, the case, I believe this case has been on your docket for 705 days. We just need a little nudge.
Okay. And Mr. Pruneda, do you have an announcement on this case?
Your Honor, we filed a response back in early or late May, referencing the correspondence between counsel. We've been in agreement, Judge, with opposing counsel as to the plaintiff's deposition notices. The problem here, Judge, and if you'll refer back to our responses back on May 7th, 2020, all we wanted was a stipulation, Judge, that we would proceed with depositions if they were willing to stipulate that we wouldn't have to renotice them because there's some outstanding medical records, healthcare records, and billing that we have not been able to recover, and I don't think opposing counsel has been able to recover. We have no problem going forward with depositions. We just don't want to have them reset once they get those records. So we're willing to get the plaintiffs deposed.
And this goes to the heart of our dilemma, Judge. We have a miscommunication coming back and forth. So back in February, I believe we were trying to schedule these up, and then we had our freeze, and then COVID happened. So Mr. Pruneda asked us to sign a stipulation where he could decide. That was the reason that we were not proceeding with the deposition. So if he decided this was really a discovery issue, then nope, that's it. You already had one bite at the apple. It's done. And that's your Honor's discretion. That's nobody else's. You're the judge, Your Honor. You want to decide that we can't go forward on a deposition because it was noticed. This is my first professional interaction with Mr. Pruneda. I mean, that's just not how we work or operate in my office. We schedule a deposition. We extend professional courtesies. If his client can't make it or reschedule it, that's fine. But I mean, that's not how things work.
I'm confused, Judge. I'm not understanding what she's saying. Again, the plaintiffs can be deposed. We're just not going to have them sit through a second deposition or a third deposition once we get the healthcare records from the hospital. That's all we're saying, and that's all we've ever been saying since May of 2020.
Okay, so if they, I need to understand this. So you're saying if they depose them right now without those medical records being available to them, then later those medical records are available to them. You do not want to make your clients available to them for a second deposition?
That's correct. I mean, we have a decision. Either they subpoena the records, because I've been unable to recover the medical and the billing records from the hospital. If we get them deposed, I don't want to have them sit through hours and hours in a second deposition once they get those records. So either we wait or we just get them done now.
Your Honor,
Okay,
respectfully,
what if-
I have never
wait,
redisclosed any of my clients,
Okay,
well,
hold
any
on.
of the plaintiffs ever. I'm not sure where
Okay,
you're
hold
getting
on.
these ideas.
But my question is what if Ms. Martinez still has time left? Like, if she reserves her time, you're still not wanting to agree to allow her to recall your clients for depositions to go over those medical records, even if she has time?
Oh, we're not talking about time, Judge. I mean, she's well within her rights to proceed if there's time available. I'm talking about having them rehash issues that have already been done. If they'll stipulate that if there's time available and they want to renotice them just on what's been remaining on those records, if there's anything that needs to get questioned, we can do that. But I don't want to have them, have duplicitous questions being asked that have already been answered.
Your Honor, respectfully, I've never done that ever. I've never gone to a deposition with the intention of doing it over again because, as everybody on this call knows, they're rather expensive. And most everyone has a lot of things to do in their time. So I've never given the impression I was going to do that. I have never expressed it by email. And if you maybe taken a couple of my calls, you would have known that was something that would not have ever happened. It's one bite of the apple, and that's what we try to work on. We just go ahead, have the deposition, take an hour, maybe an hour and a half at most if she needs, or if there's two plaintiffs, if they need translators. But we just need a date set. It can be in October, it can be November, it can be December. Fine, we're willing to accommodate them, their schedule. I've had depositions happen at 7 o'clock at night. That's fine, we roll with it, but we have to roll. We have to get these depots, or else no mediation, no settlement. And this case just sits on your docket as it was sitting on the predecessor court's docket. It's just not moving. And just crossing your arms and saying, you know what I want because I want it is not, within judicial economy. Really, it's just a waste of everybody's time.
Okay, so how much time, Mr. Brunella, do you need in order to provide your clients for the mediation? I mean, for the deposition?
We'll schedule them, Judge, if they want to proceed within the next 30 days. That's never been an issue. They were willing to be present at depots since last May. I mean, those are the facts.
Your Honor, if I could ask the court to set a date for us, or else Mr. Brunella will just continue with these games.
Okay, this is what I'm gonna do. And just because of the sake of also calendars and things will happen. So just come up with a day that you can present your clients for depositions within the next 60 days, okay? So within the next 60 days, that gives you a lot of time to work within your calendars. And I think that with you all extending each other professional courtesy, you can establish the parameters of the deposition just like any other deposition will occur. And if you think you're going to get those medical records in time, and you save some time and then depose them on those medical records. And I don't think I have to tell both of you all what kind of parameters to set. So, just work with each other on that, get the depositions done within 60 days. And if you need any help from this court after that to get a mediator or to set a deadline for mediation, just let us know and we'll be glad to do that. So I'm going to have you come back though. I'm going to have you come back on October the 13th and let's see where you are with this.
Thank you, Your Honor. I have no further matters in this court. May I be excused?
Yes, Mr. Pruneda, anything else?
That's all, Judge.
Okay, thank you. Y'all have a good day. Okay, Attorney Yuri Rocio.
Good morning, Your Honor. For the record, Yuri Rocio on behalf of Eva Salinas. We're here on number 37 on your docket, Your Honor. I have been in contact. This is a status on mediation. At our last setting, Mr. Alamia was hospitalized and was unable to meet that mediation date. We did offer professional courtesy and offer to reset that. Unfortunately, we have had some difficulties calendaring a mediation date, Your Honor, but we anticipate being able to resolve that within the next 30 days. Mr. Alamia's office was in contact with my office this morning, and we are making that joint announcement this morning, Judge.
Okay, that's on F4053-18-9 in the matter of the marriage of Eva Salinas and Oscar Salinas Jr. Okay, so then I'm going to set the deadline for you to mediate within the next 30 days then.
Yes, Your Honor.
Okay, and then I'm going to have you come back to report on that on September the 8th.
Yes, Your Honor.
At 9:30.
Yes, Your Honor.
Okay.
Thank you, Your Honor. I have no further matters. May I be excused?
You certainly may.
Thank you, Judge. Have a wonderful day.
Thank you. Likewise. Attorney Shelley Hopkins.
Good morning, Your Honor. How are you?
Good morning, ma'am. Doing well. Yourself?
Judge, I'm sorry. I'm on docket number 11. It's Leo and Angelita Pruneda versus Gregory Funding et al. CL 186390. We're here today on our motion for summary judgment. I conferred by email with opposing counsel, and I think he's going to request another continuance of this. I don't know that he actually filed one. Mr. Rayfield, are you there?
Your Honor, can I make an appearance, please, in this case?
Yes, sir.
Attorneys have announced yet. Good morning, Your Honor. My name's Tom Rayfield. I'm here representing Angelita Pruneda and Leo Pruneda. I've appeared before the court, in court, prior to this, and I will be filing a notice of appearance, but I've been at a prior hearing, and we are going to be asking for a continuance due to the cancer treatment that Mrs. Pruneda is having. She's in MD Anderson today. I provided some documents to opposing counsel. I didn't really want to make medical records part of the public record, but I can do it if you'd like. I did give it to opposing counsel. I believe that she will admit that she has that. Today, she's under a special treatment of something they call the Devil's Brew, which is an AI injection, and it's rather difficult. So it's been difficult to communicate with her at all since our last hearing due to her cancer treatment, and we are asking for a continuance at this time. I did file a motion for continuance to the last setting, and I just assumed that it would be carried over to this one, but there is a motion for continuance for the last setting. This has been reset. Thank you, Your Honor.
Okay, and how much time are you asking for, Mr. Rayfield?
My client wanted to know if we could have it set for October because she's supposed to be finished with her treatment then. If not, at least she's got to get through the chemo before I can even talk to her and get her to sign an affidavit. I mean, that's reality, Judge. That's not what I have to deal with.
Okay, Ms. Hopkins, anything else?
Judge, we oppose the continuance. We're obviously sympathetic to the cancer treatments, but this loan is due for 2010. So my client's unfortunately kind of exasperated with the length of time that they've been expending funds, taking care of the property, taking care of the taxes. Obviously, this horrible situation that she's going through, I don't want to push forward, but I did advise Mr. Rayfield that we do have a valid foreclosure judgment that's not part of this lawsuit, and we do intend on proceeding with that foreclosure suit or with that foreclosure judgment and posting this for foreclosure. So regardless of whether the MSJ goes forward today or not, we do plan on proceeding with foreclosure because a foreclosure is not barred by this suit. They didn't make the proper injunction payments here. So, my hands are kind of tied. I feel like a horrible person objecting with her cancer treatments, but it's been 11 years.
Well, Your Honor, that's a little bit misrepresentative, as if they paid nothing in 11 years, but that's what we have to expect. Your Honor, I do believe I'd like to be able to represent my clients, but it's difficult to do it when I cannot speak with them. I certainly understand opposing counsel's need to represent the bank, and I'm sure that they need their money, and we do appreciate that. However, Mrs. Bruneta, primarily Mr. Bruneta, has well maintained the home. It's in great shape. And so I don't think there's any loss to the bank. Obviously, if they're going to go forward with their foreclosure, we'll probably be filing something additional as well. I don't think it's right to kick somebody out in the middle of the pandemic that's got cancer, but that's this is what we expect from banks of this nature. And so, it is to be expected. Thank you very, very much, Your Honor. I appreciate you hearing from us today, and I hope you can give us a continuance, but I certainly understand you're the judge and you do what you think you need to do. Thank you.
Okay, so we'll return on October the 27th on this matter I'm going to do that at 11 a.m.
Yes, ma'am.
And we'll take it up at that time.
Thank you very much, Your Honor.
Okay, anything else?
Nothing further. May I be excused, Judge?
Yes, you certainly may, ma'am.
Thank you.
Nothing further. Thank you, Your Honor. Nothing
Okay.
further.
Thank you. Okay, Attorney Jesse Contreras. Attorney Jesse Contreras.
Yes, he's in the 206 right now. He's about to be done. Just give him about two minutes, please. I'm sorry.
Okay, well, I'm going to continue with the docket. He can come on as soon as he's done.
Okay, thank you.
Thank you. Okay, Ms. Williamson.
Good morning, Your Honor. We're here on number 3 on your docket, and I believe it's a default because I have not seen the respondent in this case on Zoom.
Okay, that is F3136-13-9 in the interest of a minor child. And what is the respondent's name?
Your Honor, the respondent's name is Elba Aurora Villarreal.
Okay, and was Miss Dora Garza making an appearance today?
Your Honor, she spoke to the child the first day and there's been no further communication. So I assume not.
Okay, but did she agree to the temporary orders, or are we finalizing this today?
We're finalizing, Your Honor. The temporary orders were signed.
Okay, so do you want to contact her and see if she's going to make an appearance today? I don't want to do that without hearing from the ad litem.
I have, Your Honor. I texted her this morning to let her know, but I have not gotten a response. I don't know, the court probably already knows. I think she lost her mom.
Yes.
Sometime last week. So I have not gotten a response. If the court wants to reset us for the ad litem, I don't have a problem with that.
Okay, well, let me see if someone from my staff can get a hold of Ms. Garza to see if she's in another court or if she's going to make an appearance this morning. And if she's prepared to move forward, we can go ahead and move forward today since notice has already gone out to the respondent.
Yes, Your Honor.
And if not, then we'll go ahead and reset it.
Yes, Your Honor, and I'll continue to try to get a hold of her.
Okay, I'll recall you shortly. Okay, thank you. Attorney Daniel Ramirez.
Yes, ma'am. Good morning, Daniel.
Good morning, sir.
We're number 2 on your docket, Judge.
Okay, F1092-21-9 in the matter of the marriage of Luz Davila versus Maria Davila.
Yes, yes, ma'am. That is correct.
And what is your announcement, Counselor?
Yes, I represent Luz Laura Davila. This is going to be an agreed divorce, Judge. Ms. Maria Magdalena Davila, the wife, who is a respondent, she signed a waiver of citation, but she's also signed off on the proposed divorce decree. All I need to do is prove it up, and before I do that, I'm going to ask the court to take judicial notice of all the documents on the file. in the-
Okay, the court will take judicial notice of all the documents in the court's file. And is your client present?
Yes, he's present.
Okay, Luz Davila?
Good morning, Your Honor. Good morning, Your Honor.
Good morning, sir. Okay, will you please raise your right hand? Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God, sir?
Yes, Your Honor.
Okay, you may proceed, Mr. Ramirez.
Yes, ma'am. Mr. Davila, would you state your full name?
Luz Lauro Davila.
And you live here in Hidalgo County, Texas?
Yes, sir.
You're married to Maria Magdalena Davila?
Yes, sir.
You filed a divorce petition against your wife, Ms. Davila?
Yes, sir.
Before you filed the divorce petition against her, you lived in Texas for at least 6 months and in Hidalgo County, Texas for at least 3 months.
Yes, sir.
You're asking the court for a divorce against your wife based on the ground that the marriage has become insupportable due to a discord or conflict of personalities between you and her, and that has destroyed the legitimate ends of the marriage relationship. Is that correct?
Yes, sir.
Do you have any reasonable expectation of getting back together with her?
No, sir.
From the marriage, you have a child. That's Ivy Lynn, Lynn Davila. Is that correct?
That is correct, sir. Yes, sir.
She's still a minor child, about 13 years old.
Yes, sir.
Did you adopt any children with your wife?
No, sir.
To the best of your knowledge, is your wife pregnant right now with another child?
No, sir.
The agreement you've reached with your wife is that both of you be appointed joint managing conservators, with your wife having the primary custody and the exclusive right to designate where the child lives. Is that correct?
Yes, sir.
And you're asking by way of the agreement that you be the possessory joint managing conservator. Is that correct?
Yes, sir.
As for visitation, the agreement is that you get standard visitation with your child. Is that right?
Yes, sir.
And also that you have a telephone and electronic communication with your child. Is that right?
Yes, sir.
Right now, sir, are you disabled from working?
Yes, sir. That is correct.
And are you receiving Social Security disability insurance benefits?
Yes, sir.
Is your child, your daughter, receiving through you Social Security disability insurance benefits?
Yes, sir. She is.
And she's getting $325 per month. Is that correct?
That is correct, sir. Yes.
The agreement you've reached with your wife is that you not be obligated to pay child support while your child is already receiving $325 per month. Is that correct?
Yes, sir. That is correct.
And so you're going to be making okay. And as far as medical, your child is getting Medicaid benefits, is that right?
Yes, sir. That's correct.
And you and your wife have agreed that as for cash medical, that would be a zero based on the fact that your child is getting the Medicaid benefits and the SSDI. Is that correct?
Yes, sir.
And that your cash dental support also be at a zero for the same reasons. Is that correct?
Yes, sir.
As far as the community property between you and your wife, Mr. Davila, you and your wife have agreed that you keep as your separate property any household furniture, furnishings, other personality, all clothing, jewelry, other personal effects, any cash in hand or in banks under your name, and the 2004 Chevrolet Silverado. Is that correct?
Yes, sir.
And as for your wife, the agreement is that she keep 100% interest in the mobile home and lot located at 5007 Brisas, that's Brisas Street, Donna, Texas. Is that correct?
Yes, sir, that is correct.
And she's also going to be keeping any household furniture, furnishings, other personalty, any clothing, jewelry, other personal effects, any cash that she may have in hand or in banks under her name, and any vehicle under her name and in her possession. Is that correct?
That is correct, sir, yes.
As far as the debts, you've agreed that you pay your debts that are under your name after the date of separation, and that your wife paid for any debts that are under her name after the date of separation. Is that correct?
That is correct, sir, yes.
As far as separate property, your agreement is that you're asking the court to confirm as your separate property that you have 100% interest in the mobile home and lot located at 831 Tangerine Street, San Juan, Texas. Is that correct?
Yes, sir.
And you're asking the court for a divorce, Mr. David?
Yes, sir, I am.
That's all I have, Your Honor.
Okay, the only issue that I see is just that with the Medicaid, the state is going to ask him to pay something. I think they've been asking at least, I don't know if it's $100 or not. I mean, sometimes it happens, sometimes it doesn't. If you want to proceed forward, I can approve the agreement as it is, but just so you know that it may have, the AG's office may flag it and ask him to pay something.
Yes, Your Honor.
Okay, but I'll approve the agreement as read into the record. And we'll grant your divorce today, and we'll grant the relief as requested, which will be set forth in further detail once the final decree of divorce is filed. Mr. Ramirez, just get that e-filed, and I'll get that signed for you.
Yeah, we'll e-file it today, Judge.
Okay,
Thank you, Your Honor. Will we be excused?
yes, you certainly may.
Thank you, Your Honor. Have a wonderful day.
Thank you, likewise.
Thank
Okay, Attorney Andrew Smith.
Yes, Your Honor. Good morning. I'm here for plaintiff on number 12 on the court's docket.
Okay. CL 200998-I, Discover Bank versus Carl Scalise.
I don't see Mr. Scalise here in the Zoom participants list, and I don't know how Ms. Elise Manchester was listed as defendant attorney. She's my boss. We're at the same firm, so I don't know how that happened, Your Honor.
Okay, so I know that Mr. Scalise has appeared the last several times. And
Yes, Your
the
Honor.
last time he was going to contact you all to see if there was a way to settle it. Do you know if he did?
We haven't received any contact from him, Your Honor. There's no settlement in our system, and there's no negotiations in our case notes.
Okay, and do you show that Mr. Scalise was properly served with the motion for summary judgment?
Yes, Your Honor.
Okay, and what date?
We
was that on?
served, let's see, Your Honor. Let me pull that up real quick. We sent notice of today's hearing on June 11th, 2021. And I'm pulling up my motion right now just to confirm the certificate of service on it. Let's see. And we filed our motion on the 30th of April of this year, and we sent it to the defendant via U.S. Postal Service first class mail.
Okay. All right, then you may proceed.
All right, thank you, Your Honor. This is a motion for summary judgment on a credit card action. Plaintiff requests summary judgment in the amount of $6,641.94. Plaintiff requests that the court take judicial notice of the business records affidavit of Chris LaRosa, litigation support coordinator for plaintiff, and the attached card member agreement and applicable to the account and balance matching statement showing the outstanding balance of $6,641.94. As there is no written response to plaintiff's motion on file, plaintiff is of the opinion that there's no genuine issue of material fact in this case, and that plaintiff is entitled to judgment as a matter of law. Plaintiff requests the stated balance as well as costs of court in the amount of $370.15, as well as post-judgment interest at 5% per annum.
Okay, the court will take judicial notice of all the documents in the court's file and will grant the relief as requested by the plaintiff. Do you have a judgment on file?
Yes, Your Honor, we do.
Okay, then I'll ask for that to be submitted to my queue, and then I will sign off on it. Let me just have his name called out 3 times. Mr. Damian?
Carl E. Scalise. Carl Scalise. Carl Scalise.
Okay, the name being called out 3 times and the defendant did not show. All right, Mr. Smith, then I'll have that forwarded to my queue and I'll go ahead and sign off on it.
All right, thank you very much, Your Honor. That's all the business I have before this court. May I be excused?
You certainly may.
Thank you.
Okay, Mr. Roby Flores, what do you have, sir?
Brief announcement, Judge. We filed a Rule 11 agreement. Ms. Olivares is the attorney on the other side. She's in a contested matter in the 139th. It was her motion. She's agreed to pass it. We submitted a Rule 11.
Okay, that is F1620-20-9 in the matter of the marriage of Bruno Alvarado and Amy Alvarado. Okay,
Yes.
then I'll just, since it's her motion, she'll need to file an order resetting hearing if she wants to urge it.
Understood. Thank you, Your Honor. We have no
Okay.
further business. Might be excused.
You certainly may, sir. Thank you.
Have a good day. Have a good
Thank
day.
you. Likewise. Okay, Attorney Willie Hernandez.
Good morning, Judge. Jose Hernandez here on behalf on number 18, Judge, on your docket, Lax Valley Stores versus Jose Angel Elizondo.
Okay, CL 21-1787-I, Lax Valley Stores versus Francisco Angel Elizondo. Let me just have Mr. Elizondo's name called out 3 times.
Francisco Angel Elizondo. Francisco Elizondo. Francisco Elizondo.
Okay, the name being called out 3 times and no response. Mr. Hernandez, you may proceed.
Sure, Judge. If you can just take judicial notice in the entire file, Judge.
Okay, that the court will take judicial notice of the entire file. Go ahead.
Sure, Judge. Just for the record, the lawsuit in this case was filed on May 6, 2021. The defendant was served on May 13, 2021. The answer was due on June 7, 2021, Judge. The return in this case was filed on May 14, 2021. There being no answer, this case is ripe for default judgment. As part of the record, we have included our damage affidavit from a representative of Lax Valley Stores. We have included our attorney fees affidavit from my office, along with the certificate, a last known address, and the service members affidavit, Judge. At this time, Lax is asking for a default judgment in the amount of $5,461.44, Judge. And there should be a proposed judgment in the court's queue ready for signature.
Okay, the court will grant the relief as requested by the plaintiff and as stated on the record by plaintiff's counsel, and will sign the order that as soon as it's sent to my queue.
Thank you, Judge. I have nothing further. Can I be excused?
You certainly may, sir.
Thank you, Judge. Be safe.
Thank you. Okay, Attorney Mario Palacios.
Good morning, Judge. I have page number 7, number 34, Guadalupe Monsivais versus Angelica Mendoza. I represent Angelica Mendoza, the defendant, Judge. I believe Frank Garza is the lead counsel and he is present.
Good morning, Judge.
Okay,
Frank
good
Garza.
morning, sir. CL 21-0174-I. Okay, and what is the announcement?
Judge, on this case, we're going to be coordinating the plaintiff's deposition. I've got some dates available for Mr. Palacios's office. However, Judge, I'd like to get this case mediated. I already conveyed that I do have Mike Zank available September 27th for an afternoon mediation, Judge, half day. That's the soonest date I can get somebody to mediate. Everybody else is booked based on names that we've passed back and forth, Judge. So if you could give us that maybe, end of September as the deadline, and I'll produce the plaintiff here, Judge, in the next, 30 days, within the next 30 days, Judge, for deposition. And then at that point, we'll just follow up with a status for a trial setting, Judge, because short of settling a mediation, we'll be ready to try it, Judge.
Judge, and if I may, he's correct as far as depots being requested. We are requesting plaintiff's deposition at this time. We don't have a date that's been set at this time. Looking over discovery, Judge, we still have records from plaintiff that have not been produced, medical bills and medical records from McAllen Family Urgent Care. They are alleging lost wages or loss of earning capacity. We have no wage information at this point, Judge. So there still is some discovery on top of depositions that need to be done. I understand Mr. Garza, who recently filed his designation of lead counsel about a week ago. But being that this case is early in its inception, I don't know that mediation at this point would be fruitful just after a deposition's been done, just because there's still some other discovery issues that we have, or still some discovery we're wanting to obtain from plaintiff's counsel or by subpoena. And so with incomplete medical records, I'm hoping to get those records from plaintiff before we even do the deposition, so as not to create any sort of issue where I have to come back and depose her as well. And so I'm okay with, and this being our first status hearing, Judge, I'm okay with getting another status date after depositions. But as far as like setting a deadline to mediate this case on a first status hearing, Judge, I just don't think that we're in that position at this point. If the court would like to check back with us on another status date to see if we have all records provided by plaintiff's counsel and depositions be done, I'd certainly be entertaining mediation at that point, but I just don't want to go in there blindly without any records being produced or complete medical records related to plaintiff's treatment, and then go in and then shotgun a mediation that don't want it to be, I'd like for it to be meaningful, Judge, at the time that we do get there.
Okay, so let me ask you, how much time do you think you're looking at before you get your medical records?
I mean, I would say 60 days, Judge. If we can have a status in 60 days, I'd be fine with that.
Judge, I can get all the records and lost wages within the next 30 days, Judge. That way, I would like to keep the September, end of September as the deadline. And if I, for whatever reason, can I get all the medical records provided to him within 30 days, then I'll agree to postpone by agreement, we can delay the mediation deadline, Judge. But I mean, my client's already finished treating, so it's not difficult to just get records together and file them with proper affidavits with the court and prove them up for trial, Judge. So give me 30 days to do that, and then we'll just depose her in the meantime within those 30 days. And then we'll have the mediation by the end of September, Judge. I can foresee that happening, Judge.
And Judge, I'll leave it to your discretion, Judge, but at this point, I just can't agree to go into a mediation blindly without having all completed medical records in my hands as well. He is alleging some lost wage info. The deposition may reveal more discovery that needs to be done at that point from plaintiff. And I just, again, I wouldn't want to sit in a position where I have to be put a deadline to mediate a case that's early on in its age that is not meaningful, and that's what I'd like to at least prevent. But I'll leave it to you, Judge.
Well, we'll kind of meet halfway. So what we'll do is, let's see if Mr. Garza can provide those records to you within 30 days, and we'll have you all come back on September the 8th at 9:30. And then at that point, you should know whether or not you can proceed with mediation on the 21st.
Sure thing. I'm okay with that, Judge.
Okay, thank you, Judge. Appreciate that.
Thank you, Judge. Having nothing further may be excused.
You certainly may.
Thank you. Have a good day, Judge.
All I have. Thank you, Judge.
Okay, thank you. Y'all have a good one.
Thanks.
Okay, Attorney Pepe Caso.
Good morning, Your Honor. This is item number 17 on the court's docket.
Okay, That is CL 21-1306-I, Ana Sofia Armenta Casillas versus Jose Enrique Garcia. And what is your announcement, Counselor?
Your Honor, this is a motion for substitute service. This involves a car crash. We've already been able to establish contact with the insurance company, but they don't want to take responsibility for the case, and duly so, until we serve the defendant. And we've attempted multiple times to go to the residence. We've done skip search. It seems like that is the correct address, and we do have the insurance company pretty much ready to go, just pending the citation being perfected.
Okay, and so on your motion, you have the attached affidavit on file?
Yes, Your Honor, we attempted 3, 4, 5 times, more than what's required. We went there multiple times, and so we did attach that affidavit of the attempts made.
Okay, then your motion for substitution of service will be granted.
Thank you,
And
Your
I'll
Honor.
have, do you have an order on file?
Yes, we did. We uploaded along with the motion.
Okay, then I'll go ahead and have that sent to my queue.
Okay, thank you, Your Honor. I have nothing further.
Okay, thank you. Okay, Attorney Sonia de Ochoa.
Good morning, Your Honor. I'm here on number 21 on your docket. This
I'm
is the
sorry,
matter-
what number?
21.
Okay, that is F 4346-20-9 in the matter of the marriage of Rosa Ana Herrera versus Omar Herrera Valle.
Yes, Your Honor. I'm Sonia de Ochoa's attorney for Rosa Ana Herrera, the petitioner in this case, Your Honor. This is a motion for substitute service. The respondent, Mr. Omar Herrera Valle, works in Louisiana, and we've been trying to serve him at the 906 South 17th Street in Edinburgh, Texas, and there've been 4 attempts. That's his mother's address. In the last attempt, his mother just stayed to go ahead and leave the documents with her. So we're just requesting for a motion for substitute service so that we can serve the petition, the respondent, anybody above the age of 16 at that address.
Okay, let me just ask my, Ms. Flores, were you able to get what Ms. de Ochoa?
Her last portion, no, Judge. She sounded very low.
Okay, it says there's something going on with your audio.
Can you hear me?
It's, there's some type of like echo in the background each time that you talk.
I'm not sure, Your Honor. Am I still echoing?
But I think she can hear you. Ms. Flores, can you hear her now?
She just needs to try to speak up a little more. She sounds really low, her volume.
Okay. Okay. The last part was, I believe you asked for you stated the relief you were requesting. Can you please state the relief again?
By leaving a true copy of the citation with a copy of the petition order, anybody over the age of 16 at the 906 South 17th Street, Edinburgh, Texas address.
It's breaking up. Yeah, we couldn't hear.
Can you hear me now?
Maybe, yes.
Okay. I'm asking to leave a copy of the citation for divorce for anyone over the age of 16 at the 906 South 17th Street, Edinburgh, Texas address.
Got it. Okay, that relief will be granted. Do you have an order on file?
Yes, I do, Your Honor.
Okay, I'll have that forwarded to my queue.
Okay, thank you, Your Honor. May I be excused?
You certainly may.
Thank you. Have a good
Okay,
day.
Attorney Ruben Ramirez.
Good morning, Your Honor.
Good morning, sir.
We're here on number 33 on the court civil docket, and I do see Miss by the opposing counsel here as well.
CL 21-0074-I, Jose Quiroz et al. Versus Norma Hernandez.
And for the announcement, Attorney Ruben Ramirez on behalf of the defendant, Ms. Hernandez. We're here on a status conference hearing, Your Honor. So essentially the point of this, where we are in this case is we have scheduled depositions of the plaintiff for this September, I think like September 9th or 10th, somewhere around there. We did just finish exchanging discovery. So, I anticipate probably in about, maybe 90 days or 120 days, we should be headed to mediation if and when we have all documentation and copies of the transcripts. So I don't foresee any issue at this point right now.
Okay, Ms. Padilla, any additional announcement?
No, Your Honor. Mr. Ramirez hit it right on the nail.
Okay.
Wow,
So-
two councils agreeing that quick, huh?
Yes, y'all settle. No.
I know, right?
Okay. So then, how much time will you need to give me another good status?
Your Honor, I really think realistically, maybe sometime in November, since depositions are scheduled for September 8th, give it about 30 days for us to get a copy of that transcript. Even though I have notes, it's always great for the adjusters to be able to have a copy of that, right? So that they can appraise the case properly. And, time conflict, I think we'll be able to have, mediation before then. So sometime in November, Your Honor.
Okay. Let's come back on November the 3rd.
Roger, November the 3rd at 9:30?
Yes.
Okay, wonderful. That concludes my business with this honorable court. May I be excused?
You certainly may.
God bless you. I'll take care.
Okay,
Take care, Ms.
thank
Padilla.
you.
Thank you, Your
Thank
Honor.
you. Okay, Attorney Victoria Flores.
Good morning, Your Honor. I am in item on a case with Mr. Sabo.
Okay, and what number is that?
Good morning, Judge.
Good morning,
didn't-
sir.
I didn't have the number either. I was hoping one of these other two did.
What's
I got
the
the
cause
cause
number?
number.
Number 6, Your Honor.
Okay. CL 186503-I, Genaro Gaitan et al. Versus Elizabeth Guerrero.
That's
Yes,
it.
Your Honor. I'm Roel Garcia for the plaintiffs. I'm standing in for Mr. Raul Guajardo, Your Honor, who couldn't be here this morning.
And just so the record knows who I am, Frank Sabo for the defendant.
Okay, and what is the announcement?
It's a friendly suit, Judge. It's settled, and we just need to do the prove up.
Okay, so you're ready to proceed?
That's, Roel would know the
Yes,
answer
Your
to
Honor.
that question.
Present and ready, Your Honor.
Okay, and who'll be testifying?
At this time, we'd like to call Cristela Hurtado. She's one of the plaintiffs.
Okay, Ms. Hurtado, can you hear me?
She may be needing the service of an interpreter, Your Honor.
Okay. Ms. Castaneda, can you ask Ms. Hurtado to please unmute?
Ms. Hurtado, por favor, ¿puede quitar la bocina?
Así.
Okay, ask her to raise her right hand.
Por favor, levante su mano derecha.
And does she swear to tell the truth, the whole truth, and nothing but the truth, so help her God?
Jura decir la verdad, toda la verdad y nada más que la verdad.
Lo juro.
I swear.
Okay, Mr. Garcia, just since we're interpreting this, just break it down into small questions so we can
Certainly, Your
make
Honor.
sure we get it translated correctly.
Thank you, Your Honor. Good morning, Ms. Hurtado.
Buenos días, Ms. Hurtado.
Buenos días.
Good morning.
Is your minor granddaughter Lisandra Jenica Gaitan?
Su nieta es Lisandra Gaitán.
Lisandra Jenica Gaitán.
Lisandra Jenica Gaitán.
Is her
Correcto.
date of birth November 9th, 2015?
Su fecha de nacimiento es el día 9 de noviembre del 2015.
Correcto.
Correct.
Is her social security number 190-23-3094?
El número social es 190-23-3094.
Correcto.
Correct.
Do you understand that Lisandra Jenica Gaitan's case settled for $30,000?
¿Usted entiende que el caso de Lisandra Yenica Gaitán llegaron a un acuerdo por $30,000?
Correcto.
Correct.
And do you understand that of those $30,000, $10,231.52 will go to pay our attorney fees?
Y usted entiende que de esos 30,000, 10,231.52 son para los costos de los abogados.
Correcto.
Correct.
And do you understand that $19,768.48 will be placed into the registry of the court?
Y usted entiende que de lo que los 19,768.48 se van a poner en el registro de la corte.
Correcto.
Correct.
And this amount is for the benefit of Lisandra Jenica Gaitan, your minor granddaughter.
Y esta cantidad es para el uso y beneficio de Lisandra Yenica Gaitán, que es su nieta.
Correcto.
Correct.
And you understand that this amount, $19,768.48, that is to be placed into the registry of the court, will be paid by the defendant.
Y usted entiende que los 19,768.48 se está pagando por los defendientes.
Correcto.
Correct.
And do you acknowledge that no one forced you, coerced you, threatened you, or bribed you, either on your behalf of or on the behalf of your minor granddaughter, Lisandra Jenica Gaitan?
Y usted reconoce que nadie la forzó a este acuerdo ni a su nieta Lisandra Jenica Gaitán.
Correcto.
Correct.
And you were not forced, coerced, or threatened to accept either the settlement amount or the manner in which these proceeds were distributed.
Y usted no fue forzada para llegar al acuerdo con las cantidades que se hablaron.
No, no fui forzada.
No, I was not forced.
And do you understand that the proceeds that Lisandra Jenica Gaitan will be receiving will be placed in a trust account for her sole use and benefit?
Y usted entiende que el producto de la cantidad es para el beneficio de Lisandra Jenica Gaitán.
Correcto.
Correct.
And do you acknowledge that Mr. Raúl Guajardo personally reviewed the settlement documents with you?
Y usted reconoce que el señor Raúl Guajardo revisó los documentos con usted.
Correcto.
Correct.
And you understood and agreed to the terms of this settlement?
Y usted entendió usted entendió y está de acuerdo con los términos de este caso.
Sí.
Yes.
And do you understand that after this settlement, you will not be able to file any other lawsuits or any other claims in an effort to receive more money as a result of this untimely accident / death of your son?
Y usted entiende que después de este asentamiento, de aceptar este asentamiento, ya no va a poder agarrar más.
Sí, sí entiendo.
Venir y hacer otro claim después de la muerte de su hijo.
Sí, sí lo entiendo.
Yes, I understand.
Now, under all these circumstances, do you believe that this is a fair settlement?
¿Y usted cree que este fue un asentamiento correcto y justo?
Correcto. Sí.
Yes, correct.
Have you understood all my questions here today and all the proceedings?
¿Y usted entendió los procedimientos de hoy y mis preguntas?
Sí.
Yes.
Are you satisfied with Mr. Raúl Guajardo's legal services?
¿Está usted satisfecha con con los servicios del señor Raúl Guajardo?
Correcto.
Correcto, correct.
Are you asking this honorable court to approve this settlement?
¿Y está usted pidiéndole a esta corte que acepte este asentamiento?
Correcto.
Correct.
I have nothing further, Your Honor. We passed the witness.
Okay, Mr. Sabo?
Ms. Gaitan, you understand that on behalf of your granddaughter, Lisandra, that you have the right to present this case to a jury?
Ms. Hurtado, ¿usted entiende que por parte de su nieta usted tiene derecho de pedir un juicio por jurado?
Sí.
Yes.
And you understand that if you request that the court approve this settlement and the court does approve the settlement, that you are waiving that right on behalf of your granddaughter?
Y usted entiende que al aceptar este asentamiento usted se está negando su derecho de juicio por jurado.
Sí.
Yes.
And you understand that the amount of the settlement is all that is available under the insurance policy that was in effect to cover the defendant in this case.
Y usted está de acuerdo que la cantidad que le dio es todo lo que la póliza de aseguro tenía para dar en este caso.
Sí.
Yes.
And with those two understandings, in addition to what you discussed with Mr. Garcia, do you believe that this settlement is in the best interest of Lisandra?
Y con su entender de conocimiento de hablar con Mr. García, ¿usted cree que este fue el mejor resultado para Lisandra?
Sí.
Yes.
And you're asking the court to approve the settlement?
¿Y usted está pidiendo a la corte que apruebe este asentamiento?
Correcto.
Correct.
That's all I have, Judge.
Okay, Ms. Flores, do you have any questions?
I have no questions, Your Honor. I have talked to Ms. Hurtado several times regarding the settlement and my role as ad litem in this case, and I'm asking that the court grant the settlement at this time as it pertains to the minor child, as it's my opinion that it's in the best interest of the child.
Okay. Ms. Castaneda, will you please express my condolences to Ms. Hurtado for the loss of her son?
Ms. Hurtado, la corte le da nuestras condolencias por la pérdida de su hijo.
Muchas gracias.
And that the court will approve the agreement as read into the record.
Y la corte va a aprobar el asentamiento que se ha llegado de acuerdo hoy aquí.
Okay, gracias.
Okay, thank you.
Okay, and Ms. Flores, have your fees been taken care of?
Yes, Your Honor.
Okay. All right, then is there an order already that's been circulated for signatures?
We circulated it, Judge, but we found out today that there's a change in the figures. It's not much, but we're going to have to redo it and then order new checks. So it'll probably get filed for your signature later today. And then the checks will come in a week or so, since we have to reorder them.
Okay. Then as soon as you all circulate it with everyone's signatures on it, then go ahead and e-file it and I'll have it forwarded to my queue.
Perfect. We'll do that.
Okay, anything else?
Yes, Your Honor, one small matter. Ms. Cristela Urardo, the grandmother, wanted to see if it was possible for her to withdraw or for the court to order $400 for back to school expenses for Lisandra Enica Gaitan, her granddaughter. And maybe it's not the appropriate time at this time, Your Honor, but she wants just an opinion whether it would be possible.
Okay. As long as it's being used for the child and her school expenses, I have no issue with her getting that directly paid to her for the use of the child. Mr. Sabo?
Judge, since we're doing that and we need to change the checks in judgment anyway. I think we can probably incorporate that into the judgment and put $400 payable to wherever Mr. Garcia thinks it should be payable or needs it to be payable to, and we can do it that way, if that works.
Okay.
Save a step.
In the interest of judicial economy, Your Honor, that sounds reasonable.
Or we'll just add $400 to the amount payable to the attorney, and then he can issue the check directly. Does that work?
I don't have an issue with that. Mr. Garcia?
Your Honor, I'll go ahead and let Mr. Guajardo know about this, but it sounds reasonable.
Okay, and I don't see that Ms. Flores would have an objection to that.
No, Your Honor, she had expressed that to me, and I did tell her what the court reflected, that as long as it's used for school expenses, generally, the court will allow. But like Mr. Sabo said, because they're gonna have to change the judgment anyway, it would save me an extra step, and the court, you would just be more efficient that way.
Okay, that's fine with me.
400, right?
Yes.
Got it.
Yes, that's what she's requesting.
We'll make that change, Judge, and it shouldn't be a problem.
Okay,
Thank you.
all right, no problem. Okay, anything further?
Nothing further from the plaintiff, Your Honor.
Nothing from the defendant.
Okay,
Nothing further, Your Honor.
okay, then go ahead. Everyone is excused, and Ms. Castañeda, can you please let Ms. Hurtado know that she's excused?
Ms. Hurtado se puede retirar.
Okay, muchas gracias.
Thank you.
Thank you, Judge. Good to see you.
Thank you. Likewise. Okay, Attorney Hitesh Shugani?
Good morning, Your Honor. I'm here on number 9 on the court civil docket. Ms. Gina Vela is opposing counsel, Your Honor.
CL 183918-I, Damaris Cardenas versus Leo Garza et al.
Yes, Your Honor. I believe Gina was there. I did see her.
Yes, Your Honor, I'm present.
Okay.
Hi, Gina. Judge, first off, I think we need to address plaintiff's motion to retain. This case was disposed on the court's DWAP docket, unknown to plaintiff's counsel, to myself. Judge, I did file my motion to retain, essentially explaining to the court the situation. So I'm asking the court to retain this case on their docket. It is from 2018. However, this is a case that has to go to trial, and we've kind of been in a holding pattern because of COVID. Prior to the DWAP, I had actually filed a motion. There was some discovery being exchanged. So even that, Judge, this case was not just sitting there. There was some actual movement on it. So I would ask the court if the court could retain this or grant my motion to retain, and then we can proceed on my second motion, Your Honor.
Okay, Ms. Vela, do you want to put a response on the record to the motion to retain?
Your Honor, this case, I believe it was originally out of County Court 5. I believe it was County Court 5 that initially set it for DWAP when it was transferred to your court. So I would just leave it at the court's discretion. It was heard on June 2nd, and I believe the order of dismissal was just signed on the 13th of July.
Okay. Well, the court will grant the plaintiff's motion to retain the case on the court's docket.
Thank you, Judge.
Okay, and the next order of business?
Judge, the next order of business we have is plaintiff's motion for net worth discovery for our gross negligence claim, or in the alternative, a motion to compel. We have previously requested, speaking about the discovery I mentioned earlier that was sent a couple of months ago, we've requested tax returns from the defendants. Reason being, Judge, is that we have alleged gross negligence in our claim against the defendants based on some testimony that was given at the deposition of the driver, Mr. Leo Garza. Our allegation of gross negligence comes from the admittance from the driver that what he did was risky. He admits he made a decision to reach for some candy or chocolate as opposed to paying attention to the road. He admits that that action was risky. Judge, so we're essentially proceeding on a gross negligence claim, and we don't need to prove that gross negligence will be a claim or that it's a viable claim necessarily in the future, but just that we have some likelihood of success on our merits for our claim of gross negligence or exemplary damages. So we've requested those records. We were met with an objection from the defense, which is obviously something we expected. So then we proceeded to file this motion, Judge, asking for the tax return information for the defendants in this case, Judge, due to that gross negligence claim. So we're asking the court to order the defense to tender that discovery over to the plaintiffs, Your Honor.
Okay, Ms. Bella?
Your Honor, we're going to stand by our objection. We're objecting on the basis that when it exceeds the scope of the discovery, it Texas Rules of Civil Procedure, and it's seeking information that's irrelevant, inadmissible at trial, not reasonably calculated to lead to discovery that's admissible evidence. Now, furthermore, with his claim of gross negligence, Your Honor, it's our position that there's no merit to the gross negligence claim. Now, gross negligence itself can be supported, or the courts have held that gross negligence can be supported only by an extreme degree of risk, not a remote possibility of injury or even a high probability of minor harm, but rather the likelihood of serious injury to the plaintiff. An act or omission that is merely thoughtless, careless, or not inordinately risky cannot be grossly negligent. It's our position that him reaching for something out of his cup holder does not amount to gross negligence on this matter. And for that reason, we're standing by our objection to the tax documents.
Well, Judge, we would respond that taking your eyes off the road, again, this would go, I guess a jury would decide if this is considered gross negligence or not, but we believe we have enough of an allegation of gross negligence. We don't need to prove a prima facie case, but we only need to prove a prima facie case, not that we're likely to win on our claim of gross negligence, but the fact that the defendant has admitted that, yeah, what I did was risky. The definition of gross negligence is that when viewed objectively from the standpoint of the actor at the time of its occurrence, the actor or the occurrence involves an extreme degree of risk considering the probability and magnitude of potential harm to others. I think if you take your eyes off the road and you admit you did that, I would believe that would fall under an extreme degree of risk and not considering the safety and well-being of others around you. So again, Judge, we're not here to say that we have gross negligence tied up in a bow. We believe that we're allowed to proceed on discovery into gross negligence. And just another little matter, Judge, a jury must consider multiple factors in determining the amount of an exemplary damages award, including gross negligence. That's including the net worth of the defendant. So what we're saying is, if we are even to get to that, we should get discovery on that, Judge, because number one, Allstate is not going to pay gross negligence for their insured. So we need to see, do they even have the funds to pay a potential gross negligence claim? Is it viable? That's what discovery is. So addressing scope and relevance and all that, I mean, we believe it is relevant. We believe we do meet the scope, Judge. I think it just comes down to what the court decides. Do we have a shot at gross negligence here? We believe we do based on the testimony. And we're just asking for tax returns. The defense always asks for tax returns from the plaintiff. We would ask the same, Judge.
Okay, anything else, Ms. Bella?
Your Honor, just to reiterate our objection, it's not going to lead to any admissible evidence. And again, the objective standard for gross negligence is higher, that it's an extreme degree of risk and be distinguishable from ordinary negligence. And I don't believe that is the case here.
Okay, so I'm going to take your arguments and I'm going to take your motion under advisement. Make sure you have your orders on file that you want me to consider, and I will issue a ruling within the next 14 days.
Yes, Judge.
Yes, Your Honor.
Okay.
Nothing further, Your Honor.
Okay. All right. Then what we'll do is aside you started your depositions. What else are y'all lacking in discovery?
Judge, we've done extensive discovery on this. You know, I was gonna ask Gina, I don't even know if we've mediated. This case is old, Judge. I'm sorry. I don't remember if we've even mediated this case.
Oh, it's not that old. Being on the bench only 7 months, trust me, this is not that old. So are y'all ready to mediate this?
I think after a ruling on this, Judge, I don't see an issue with mediation. I'll be honest with you, Judge. I would ask the court to direct counsel for Allstate to have, you know, if the court's going to ask us to mediate, to have one of the defendants there. I know they don't like to have their clients there, but we have our plaintiffs there. We respectfully ask the court to order defense to make sure that one of their defendants are there, whether it's Leo or Sandra Garza. They should be participating in this claim. This is not just my client versus Allstate. This is my client versus Mr. and Mrs. Garza. So if we're going to mediate, we would like them there. They should participate, Judge. They should push their insurance company. Hey, maybe we should settle this case instead of, you know, going to trial. They should participate, Your Honor. So we're just asking for that ruling or that order to defense counsel if we're going to mediate.
Okay, what I'm gonna do is I'm gonna go ahead. I'll issue my ruling within 14 days, and at the same time, I will also issue my order of referral to mediation, and there will be some instructions in there for you.
Thank you, Your Honor.
Your
Okay.
Honor, just in response, it's not our common practice to require that our clients be there. It would be the adjuster and myself. It's always been that way. It's common practice, and I've been practicing for 2-3 years now, and I've never had my client present during mediation.
Okay, I understand. But
Your
I understand your position, but I'll be honest, I've never understood why they weren't there, because then something comes up and then, oh, well, let me find out from the defendant or whatever. And it's just, and, you know, and it also depends on the claims, you know, as to some of the actions. And I'm sure, I mean, if he's claiming gross negligence, that might be a time for your adjuster to actually have a conversation with the defendant and as to what actually happened. But we'll see. I'm going to issue some instructions in that order, and if that's on there, then I expect that you all will abide by the order. Okay?
Yes,
Yes,
Your
Your
Honor.
Okay. So if nothing further, then what will also be included in the order is your next status hearing date. Okay?
Yes, Judge.
Okay. Then we'll see you soon.
Thank you, Your Honor. Maybe
Thank you, Your Honor.
Yes, you certainly may. Thank you.
Thank you.
Okay, Attorney Renee Castellanos.
Judge, good morning.
Good morning, sir.
On number 14 of the court civil docket.
Okay, CL 22595-I, Ricardo Mazo versus Emmanuel Martinez.
Rene Castellanos for the defendant, Emmanuel Martinez, Judge.
Okay, and is Mr. Wilson appearing today?
I have no idea, Judge. I've had no contact with his office. He hasn't reached out to me. It's his motion for summary judgment, my motion to dismiss the case in its entirety. Just to give the court some background information. This case involves a lease for a business premises. The basis of our motion to dismiss is that the plaintiff does not own that premises. We're simply asking for the right party to bring the lawsuit, not this particular party. They filed a motion for summary judgment, but of course, our allegation is that the court lacks subject matter jurisdiction because the plaintiff has no standing to bring the lawsuit. So if that's the case, the right party can bring the lawsuit at whatever time they choose to do so. That's the party that's been aggrieved, not this particular individual.
Okay, and I see that there was no response filed to your motion to dismiss. Is that correct?
That is correct, Your Honor.
Okay. Okay, let me just call, Mr. Damien, can you please call out Ricardo Mazo 3 times?
Yes, ma'am. Ricardo Mazo. Ricardo Mazo. Ricardo Mazo.
Okay, and is anyone here on behalf of Mr. Mazo or stepping in for Mr. Wilson? Okay, this matter was set for 9:30, so Mr. Castellanos, you can proceed with your arguments?
Okay, Judge. We have essentially filed a motion to dismiss. The defendant has. The basis for that motion is that the wrong party has brought the lawsuit, in our opinion. The lawsuit was brought by a Ricardo Masso. We've provided exhibits to the court to show that the proper owner of the property is a Javier Masso and a Kathleen Masso, not the Ricardo Masso that has brought this lawsuit. Those parties, if they choose to do so, can bring the lawsuit on their own. Ricardo Masso is not the proper party, and we're asking the court to dismiss the lawsuit, Judge.
Okay. 1 moment. Okay, I'm sorry, Ms. Rivera, you were saying that the link was sent out on,
Yes, so just for confirmation and for clarification of the record, we did send Mr. Paul Wilson the link on June 23rd at 1:29 p.m. It was
For
sent by for today's hearing, yes, ma'am.
okay. Okay, and so then I'm not going to take up the second motion for summary judgment because at this time it's not being urged. What I'm going to take up first is there was a motion to withdraw filed, I believe, by the person that had the case prior to you.
That is correct, Your Honor. I'm sorry.
Okay.
It's Attorney Crystal Garza, I believe.
Yes, so I'm going to have that order granting her withdrawal sent to my queue and I'll sign off on it. And then on your motion to dismiss, I did read your motion along with the attached exhibits, and we'll take judicial notice of the documents in the court's file. And we'll also take judicial notice that the parties were properly served with today's hearing information, and the court will grant your motion to dismiss. So that order granting, if it's not on file, get it on file so it can be sent to my queue.
It was filed at the same time the motion was, Judge. 1/20/21, so it should be in the court's queue for signature.
Okay, then we'll go ahead and look for that later today.
Very well, Your Honor. May I be excused?
You certainly may.
Thank you, Judge. Have a good day.
Likewise, Attorney Alexandra Huerta.
Good morning, Your Honor. Alex Huerta on behalf of the state and the applicant for the protective order number 25 on the docket.
Okay, that is P0254-21-9, Lilia Valdez versus Abraham Valdez.
Alex Huerta for the state and the applicant. The applicant is also present via Zoom under Lilia Valdez, I believe.
Okay, and what about the
Judge, I don't show that he is here. He has been served. He was served on 7/15 of 2021. If he is not present today, we would like to proceed with the default judgment.
Okay, Mr. Damian, please call out the name 3 times, Abraham Valdez.
Abraham Valdez, Abraham Valdez, Abraham Valdez.
Okay, the name being called out 3 times and no response, you may proceed.
Your Honor, at this time, the state would like to admit State Exhibit 1 into evidence, which is will be her affidavit that she has previously been e-filed. We will e-file it again.
Okay, that'll be admitted.
We're asking the court to find that that Mr. and Mrs. Valdez have a formal married relationship and that they are biological children, parents of children together, that the respondent has committed acts of family violence and is likely to commit family violence in the foreseeable future. As far as orders regarding the minor children, there is a case under F-0975-21-9. In the interim, we would ask that the court appoint the applicant sole managing conservatorship and deny visitation at this time. We would ask that when and if he does obtain visitation with the children, that he continue to refrain from drugs and alcohol when having possession. Child support will also be handled through F-0802-21-9. We are asking that the court prohibit the respondent from committing acts of family violence, directly or indirectly communicating in a threatening or harassing manner with the applicant or a member of her family or household, or communicating with her in any manner except through their attorneys, from engaging in conduct that's likely to harass, annoy, alarm, abuse, torment, or embarrass that person, from harming, threatening, or interfering with the care, custody, or control of a pet, companion animal, or assistance animal, or from removing that animal from her possession, from going within 200 yards of the applicant and her family or household, from going within 200 yards of their residence, school, or place of employment, from interfering with her possession of the children, from transferring, encumbering, or otherwise disposing of any mutually owned property, and from possessing a firearm. If he has a license to carry, we ask that it be suspended and he be ordered to surrender any firearms to the Hidalgo County Sheriff's Office within 10 days of the signing of this order. We ask that the court costs be waived and the protective order be in full force and effect for 2 years until July 26, 2023. Your Honor, if we may swear in Ms. Valadez so I can ask her a few questions.
Yes, Ms. Valdez, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, ma'am?
I swear.
Okay, you may proceed.
Can you please state your full name for the record?
Lilia Garcia Valadez.
Ms. Valadez, you and I have spoken at length about the allegations that you've made in the final protective order in this case. Is that right?
Correct.
And that agreement that I just read onto the record, is that what we discussed?
Yes, ma'am.
And is anyone forcing you or coercing you into agreeing to the document?
No.
Are you doing this of your own free will?
I am.
And are you asking that the court grant the protective order as was read onto the record?
Yes.
I have no further questions, Your Honor.
When did the incident occur that initiated this protective order?
Your Honor, I believe there's been several incidents. The one in particular that was the straw that broke the camel's back, so to speak. If I may just have one moment to, I believe it was June 19th, 2021.
Okay. Okay, Ms. Valdez, the court is going to grant your protective order and the relief requested and stated on the record by Ms. Huerta. Who is your attorney of record for your divorce and the SAPSR that you have pending?
I don't have one right now. Mujeres Unidas set me up to see if I could get, I was trying to do it on my own, but it's kind of gotten beyond what I can do. So they were going, I have on Wednesday an appointment for intake to see if I qualify for help with the state for the remainder of my divorce.
Okay. And because since you have 3 cause numbers, of course, the protective order is on its own, but you have your divorce and you have a SAPSR, which was done prior to your divorce. And now since they all deal with those 2 cases, you have to consolidate them.
Yes.
And so the only way that I can keep track of them is if something is going to happen on them, right? I mean,
yes,
you have a protective order right now, which is going to ensure what your conservatorship role is and that no visitation occur at this time until further order of the court. But I can't just let it linger on my docket. So what I'm going to do is on these 2 cases, on the F0975-21-9 and F0802-21-9, I'm going to set those 2 cases for a status hearing. And I'm going to set that for September the 8th. That'll give you enough time to get your appointment with Mujeres Unidas or see how you're going to proceed. And that way we know what we're going to do, because I think you are correct. I think you've reached the point where you do need the services of an attorney because there's too many things that you need to do procedurally. And unless you have an attorney assisting you with that, I think it's a little over your head.
Yes, I agree.
Okay.
Thank you.
All right. Then we'll see you back on those cases. And then Ms. Huerta, I'm sorry. As soon as that's filed, then I'll go ahead and have my my staff forwarded to my queue, okay?
Will do, Judge. We'll have it filed probably this afternoon, and we'll call the court with the docket number or with the envelope number.
Okay, sounds good.
Great, thank you. We have no further business. Any excuse?
You certainly may.
Have a wonderful day.
Ms. Williamson's office, we did receive notification from Ms. Garza that she is out ill today.
Yes, Your Honor. Ms. Williamson had to step out also due to an emergency with her mother. So
Oh.
you have Mr. Adolfo de Leon here present, and she would just wanted me to make an announcement to you to see if we can just get a reset date.
Yes. We will go ahead and have you all, since it's a default, we're just gonna need time to go ahead and send her notice. And let me see. Let's come back on August the 25th. And just make sure that all parties are notified.
Yes, Your Honor, we will.
Okay?
Thank you, Your Honor.
Thank you. Okay, Attorney Eddie Garza?
Good morning, Your Honor. Eddie Garza here on behalf of Sherryland ISD on docket number 13.
Okay, that is CL 201757-I, Stephanie Smootha versus Sherryland ISD.
And Ms. Namuda is pro se, Your Honor, and I did notice that she is live on the stream.
Okay, Ms. Smootha?
Good morning, Your Honor.
Good morning. Okay, so we're here on your plea to the jurisdiction, Mr. Garza?
Yes, Your Honor. This claim actually arises, it's a Texas Labor Code claim based on disability, gender discrimination, and retaliation. But what we're here to talk about today is really a jurisdictional argument. It has to do with this case potentially being barred by limitations due to jurisdiction. So it's not really an argument on the merits of the cause of action, but really just limited to the concept of jurisdiction. Because as you know, the defendant's a governmental entity. Therefore, in order to sue the government, you have to be able to satisfy some prerequisites, including satisfying those that come with the Texas Labor Code. So to give the court some quick background, this was a recommendation to non-renew Ms. Samuda, who was an instructor for the district. That recommendation to non-renew her based on what the district has stated is really performance-based issues. That recommendation to non-renew was voted on and approved by the Board of Trustees on January 21st, 2019. Now, the following day, and this is the date that has the most relevance to the jurisdictional argument, Your Honor, on January 22nd, 2019, the plaintiff was specifically put on notice in writing that the board had taken action and had already voted to initiate the process of non-renewing her employment with the district. Okay, now, on that, the reason that January 22nd date is so significant is because that's the date when the plaintiff was informed of what she claims is an allegedly discriminatory action, right? The process of having her non-renewed through the district. Well, under the Labor Code, section 21.202, the plaintiff has a 180-day time limit, right, statute of limitations, to file a charge of discrimination. So even though the decision had not yet come to full fruition, the Texas Supreme Court has stated in Specialty Retailers versus de Moranville that once the plaintiff's is aware or informed of what she claims to be a discriminatory act, your 180-day calendar starts to tick. So under the Texas Supreme Court case law and under section 21.202, the plaintiff had until July 21st of 2019 to file her TWC complaint with the Workforce Commission. That's 180 days from the date the plaintiff was informed that the board had voted on the proposed non-renewal. Now, arguably the day before, when the board took official action, the whole public is on notice, right? Because the action was taken before publicly, but she was specifically made known on January 22nd. So 180 days from that day runs to July 21st. The plaintiff didn't file a charge of discrimination in this case until August 1st of 2019. So while her statute of limitations at 180 days ran on July 21st, she didn't actually file a TWC complaint until August 1st of 2019. Now, these exhibits are all part of the plea to jurisdiction. They're set out. Everything is very well documented for court's consideration. But because she didn't, essentially because she didn't trigger the 180-day deadline, her claim is barred by limitations, which means she wouldn't have accomplished the necessary prerequisites to sue the district. Therefore, there's no waiver of immunity and there's no jurisdiction to hear the case. Now, in fairness, if she had been suing a private company, Walmart or anybody, Hager Slacks, you still have 180 days. And if it doesn't happen, that case gets dismissed and there is a jurisdictional issue. But with respect to the government, it's even a step further because you also have to trigger a waiver of immunity in order to sue them. So there's really a twofold argument there regarding the lack of jurisdiction on the claim. So irrespective of the grounds for why she was non-renewed, which is not an issue for jurisdiction, it's a simple fact of statutes of limitations. She had until July 21st, 2019 to file. She didn't file her TWC complaint until August. So therefore, Your Honor, we're asking that the court dismiss this claim based on a want of jurisdiction.
Okay, Ms. Nuda, do you have a response?
Yes, I'd like to go in order to the arguments that he presented, and I would like to address the issue of the cause of action being filed with the TWC within a timely manner. I would like to say that it began on February 20th, 2019, because I was going to be speaking before the board on the 13th of February. So there's no way that I would have been able to file any kind of EEOC charge or TWC charge because nothing had been determined yet. So I had to wait until the board made a final decision. Also, I would like to state that since it was filed on August 13th, 2020, I was still within the time frame. And also, there's no docket control order in place. So I'd like to request that the court abate this case until a similar case that was actually handled within your court with Patricia Orozco, and the cause number is CL-20-0676-D. That was an order denying the defendant's plea for the jurisdiction, and it's also with the same defense attorney, and it's in the appellate court system right now. So since that was denied, I'd like to abate this case, well, not the entire case, but I would like to abate the decision on the jurisdiction issue until the appellate court system has reviewed that case. Thank you.
Okay, you don't have a written response to the plea to the jurisdiction, so are you just asking the court to consider your oral response?
Yes, please, Your Honor.
Mr. Garza, anything else?
The only thing I would add, Your Honor, not to belabor the point, but I do think that the record speaks for itself. Certainly, it articulates the jurisdictional facts and jurisdictional evidence, but every single case every plaintiff has to establish jurisdiction for themselves. They have to have evidence specific to that particular claim and those particular circumstances and facts. So the suggestion that the case be abated because of some other jurisdictional facts and jurisdictional issues or cases, I don't think that would be proper at all, because each plaintiff has to satisfy it. The second thing is, as the court is well aware, jurisdiction is something that we want to handle up front, because if there is no jurisdiction, then obviously the rulings from the court, we wouldn't want to be making rulings and issuing orders and incurring the costs of defense and prosecution, and just to find out later on that jurisdiction wasn't an issue proper, which is why we filed it. So that's all I have to add, Your Honor.
Okay, and also, did she follow all of the prerequisite steps through the grievance process? Does she go through level 1, level 2, and level 3?
Without having the review of the file directly in front of me, from what I can gather, I believe she did. But with respect to the cause of action that was filed here, she would have had to trigger it through the TWC, irrespective of whether she went through the grievance process.
Okay, and do each of you have an order on file?
We should have a proposed order attached with our plea, Your Honor.
Okay. All right, well then I'll issue a ruling within 14 days. So I'll have a tickler set for that.
Your Honor, how will I be notified of this?
Email.
Okay, could I put my email on record?
Yes, you can.
Okay, should I just contact the bailiff?
No, you put it on the record now.
Okay, s.a.zmuda@gmail.com.
Okay, and Mr. Garza, does that email, is that reflected on your order?
Whatever email we would have been provided would be there, but I think the plaintiff obviously got notice of this particular hearing. So whatever's in the electronic queue, I think is maybe where those are being sent. But
Okay, I do see that you have her physical address, but now that she's given the email, if you can please file another order
okay.
with that email address. That way my staff knows who to CC on any order. Now, Ms. Smootha, I also see that you have a motion for leave to amend county to include federal violations and complaint for employment discrimination. Just so you know, you did not file an order setting hearing on that, so that is not being taken up today.
Okay, thank you.
Okay.
And to address that briefly, Your Honor, the case was actually removed based on that federal court, one of that allegations containing federal allegations. So it was in federal court for a little while. She did not amend her complaint while in federal court. So Judge Hinojosa remanded it back to state court, which is where we're at. That's why we're hearing the plea. If I could just confirm though, Your Honor, I want to make sure I get the email right so I don't send it wrong. I have S as in Sam dot A as in Alice dot ZMUDA@gmail.com.
That's correct.
I'll be happy to amend the order, Your Honor, to include that, and I'll have it submitted.
Okay, thank you.
That's
Y'all
all.
have a good day.
Thank you, Your Honor. Have a great day.
Thank you. Okay, Mr. Moreno?
Yes, good morning, Your Honor. I think it's still morning.
Yes. My 15 minutes, sorry about that.
Well,
for the
that's
long
okay. My
docket.
case has been pending for a while too. Mr. Ignacio Perez is also on the line. If he can unmute. I'm sorry, he's also in on the Zoom. He may be in the courtroom.
Yeah, he is right. Yeah, I see him. So it's CL 151106-I, Lord and Gonzalez versus Ignacio Perez et al.
Yes, ma'am. We've just recently gotten service on his daughter, who's the last defendant that needed to be served. The answer is not due to the middle of August. Mr. Perez advised me, he called me and asked me if I would agree to extend him time so that he could have time to look for an attorney. He had an attorney in the past and that attorney withdrew, and he now, I think, wants to get another attorney to represent him and his daughter. And I think he needs some time. I'm not sure how long.
Mr. Perez, are you still looking for an attorney? Press that little microphone in front of you on the screen. Mr. Perez, you're on mute. If you'll see on your screen, there's a little microphone there. Do you know if he's Spanish speaking or English speaking?
Oh, he speaks both, ma'am.
Okay.
But he's a little older and sometimes maybe a little hard of hearing.
Okay, Mr. Perez, give me a thumbs up if you can hear me. Give me a thumbs up if you can hear me. Go like this if you can hear me. Can you hear me? Okay. So I'm going to grant your request to get an attorney, okay, for you and your daughter. So your daughter's answer is not due until the middle of August. So I'm going to give you some time to also get the attorney. So I'm going to have y'all come back on September 29th. September 29th for a status. Because I want to see if you all have hired somebody by that time.
Your Honor, to make it easier, I'll submit an order setting that hearing so he can be served with something.
I appreciate that.
Yes, ma'am.
Okay, so we'll see you back here on September the 29th at 9:30.
Okay, thank you, ma'am.
Thank you, sir. Okay, Ms. Portis?
Yes, Your Honor.
Okay, did you have one more case?
I do. It's number 39.
Okay. CO 160-185-I, Progressive County Mutual Insurance versus Jessica Elaine Trevino. Okay, and are you ready to proceed on your bench trial?
We are, Judge.
Okay, Mr. Damien, can you please call out Jessica Elaine Trevino 3 times?
Jessica Elaine Trevino. Jessica Trevino. Jessica Trevino.
Okay, the name being called out 3 times, you may proceed.
Yes, Your Honor. I first would ask the court to take judicial notice and enter into a business records affidavit that we have filed on August 27th of 2018.
Okay, the court will take judicial notice of all the documents in the court's file.
Thank you, Your Honor. And attached to that business records affidavit are damages that show that the insured Gilberto Sandoval was compensated in the amount of $8,463.26. I'm also showing in the court's record that, and in that affidavit, it showed that the accident occurred on January 17th of 2014. And the defendant was the proximate cause or a negligent driver and caused the damage to the insured's vehicle and body at that time. I'm showing that suit was filed on January 13th of 2016. Defendant was served on May 4th of 2016. Defendant filed a pro se answer on May 27th of 2016. And they've been noticed of this trial setting on June 9th, 2021. They're not here today, so I'd ask the court to grant judgment as requested. Not sure if we have a proposed order on file. If not, we can get one sent to the court. But we're asking for $8,463.26. And
okay. Okay, then the court will grant the relief as requested against the defendant, and you'll take the judgment in the amount of $8,463.26. And if an order is not on file, go ahead and get one filed.
Thank you, Your Honor. We'll do that. That's all I've got for today.
Okay. And I'm going to set a tickler for that just to, do you have one on file? Do you know?
I have a hard copy here in front of me. I believe we did file one at some point, but I don't have confirmation of that. So we'll get one sent over.
Okay, just make sure that it is. I'm just going to set a tickler for August the 13th, just to make sure. Okay.
Thank you, Your Honor.
All right. Okay, so I have F1091-21-9 in the matter of the marriage of Roberto Navarro versus Perla Navarro. And I have them as pro se. Mr. Roberto Navarro, are you present?
Yes, ma'am.
Okay, and Ms. Perla Navarro, are you present?
Yes, ma'am.
Okay, so both of you are representing yourselves?
Yes, ma'am.
Okay, let me just make sure that you have filed everything. Do you all have any children?
Yes, 3.
And have you signed a final decree of divorce that's been filed with this court?
I believe so, yes.
Okay, I don't have one. I don't know if my court coordinator can confirm. I have an original petition for divorce. I have the waiver of service that was signed by Ms. Navarro. And then there was a notice that was sent, but I do not have a divorce decree on file for the both of you.
Oh, no, then that's what's missing then, ma'am.
Okay, so that divorce decree has to be signed by both of you and filed before you can go forward with your divorce. Okay? Because that tells the court that you have settled all the issues with respect to conservatorship child support, medical support, and any debts that you may have, okay? So you need to have that done. Then once you have that done and you both sign off on it, then you can come back and go ahead and get that proven up, what we call prove up, okay? So
Okay.
how much time do you need to get that done, Mr. Navarro?
Like a week.
Okay, so do you know where to get that information?
No, not really. I was just gonna look it up or go into the
Okay,
courthouse.
because I can't give that to you. So you do need to make sure. Now, what I'm gonna do is, I think you're gonna need a little bit more than a week, because there's gonna be some things that that are gonna come up, and you're probably not gonna really know how to respond to it. So I'm gonna have you come back on August the 25th. Now, that hearing will only occur if your divorce decree is filed with both of your signatures on it, okay? I'm gonna make that clear. That hearing will only occur if the final divorce decree is filed. If you don't file it before that date, I'm not gonna hear you, okay?
Can we change the date?
Okay.
I have Monday and Tuesdays off work.
Okay, so then we can do the 23rd.
Okay, that's perfect.
Okay,
That's okay with
anything
you,
else? So,
No.
do you all still communicate with one another then?
Yes, we.
Oh, yes.
Okay, well, since y'all communicate, it shouldn't be hard then to get that done.
Correct.
Okay, thank you.
Thank
Okay,
you.
F1202-21-9 in the matter of the marriage of Shanoa Hurtado versus Victoriano Hurtado.
Yes, ma'am.
Okay, and is Mr. Hurtado present?
No.
Okay. Okay, so I do see that you have a divorce decree that has been filed on July the 26th. And that divorce decree was signed by your husband as well, is that correct?
Yes.
Okay, I'm just gonna go over the decree to make sure you did everything. Okay, so you used to have a case F3970-18-4?
Yes, that's what I have it under. That's for my, I think that's for my.
Child support?
Yes.
Okay, hold on.
I wasn't sure if I was supposed to submit that as well, but.
Well, it's not that. The thing is that procedurally, since that case was done, hold on.
Okay.
Okay. So you have a SAPSER that was filed in County Court at Law Number 4 back in 2018. Is that correct?
Yes.
Okay. Now, the issue becomes that by the family code, that court number 4, has jurisdiction of your children and will always have jurisdiction of your children unless there is a transfer that is filed into this court. So technically, when you filed your divorce, that divorce should have been filed in county court at law number 4, unless there was a transfer. Now, I don't see a transfer. I don't know if my second pair of eyes, my court coordinator can look, but I don't believe we received this as a transfer. So what I have to do now, because I'm glad you put that on that decree, but you filed that on July the 26th. So what I have to do now is I have to file a transfer request to county court at law number 4 so that they can transfer that SAPSR to me. Then you have to have both, you're gonna have to consolidate that one into this one, and you can, we can do that orally, just for the sake of procedure, okay? Then I can divorce you.
Okay.
Okay, so, but we'll get that sent over to county court at law number 4 by today or tomorrow. It usually takes about 24 hours or so. Then we have to wait for that to get sent back to us. When it's sent back to us, then I can go ahead and hear you. So I'm going to give us plenty of time. And I know the last time it was because you had to get your decree filed, and you filed your decree. But now with that new piece of information on your decree, excuse me, now this is what we have to do. So I'm going to have you come back on August the 25th. Okay. If for some reason we do not have the transfer by that date, we will notify you, and we'll have to give you a date after that. Okay. Once we have that transfer, we can hear you. We should have it by that date. And so when we have you come in that day, we'll double check that we have the transfer, and then we can proceed. Okay. Now, if all of that is done, just put your reaction button. If you have a reaction button, because that's what's called a quick announcement. If you have a reaction button, use it, and it'll move you to the front. Because if you don't, then I'm going to call you to the end.
Okay.
And I know sometimes people don't do it because they're not sure what to do, but you should be ready. Once that's done, your divorce decree has been filed and both of you signed it, so you should be fine.
Okay.
Okay?
All right. Thank you.
Okay, then we'll see you on that date.
Okay. Thank you.
Okay, thank you. Okay, so I have F4031-20-9 in the matter of the marriage of Diego Rivera versus Cheyenne Carrasco. Mr. Rivera, can you please unmute yourself and turn on your camera?
I'm here, Your Honor.
Okay, I'm gonna go ahead. So are there any minor children involved?
Yes, we share a daughter.
Okay, I do see that you all have filed a final decree of divorce. And that has been signed by both of you. Do you have any other pleadings, any other, like the SAPS or anything like that that has been filed, a child support case, anything like that?
My only question would be, once we file this, we had already set up where payments would be withdrawn from my account. Would it take effect after today?
Who did you set those up with?
That was, I believe, in the paperwork that was filed to you, to the, excuse me, the district, the county court.
But did you turn this in? Who is going to be arranging for that to be taken out, is what I'm saying.
I've
Oh, sorry, Your Honor. I've actually been in touch with the Attorney General about this. So as soon as the divorce is finalized, I'm going to reach out to them once again and see the status on when we can set up.
Okay, so you all have that child support is $450 to be due on, and with the first payment on June 25th. So did Mr. Rivera, did you pay that $450 on June 25th?
Yeah, I've been making payments. It's just something we do directly. Like it doesn't go through like a court system or anything. So I didn't know
Okay.
if that was gonna change.
How long have y'all been doing that?
It's been over, I want to say over a year.
Okay, so Miss Carrasco, are you going to be making a claim that Mr. Rivera owes you any back child support?
No.
Okay. So there on your divorce decree, if you will look on page 10, it gives you directions as to where to mail the payments. You will have to mail the payments until those payments are deducted from your employer. Because you all checked off that there's a suspension of income withholding, which means that you will be mailing the payments directly to that address every month until, if for some reason you're late, then you can have them withdrawn from your check. Is that going to be your agreement?
Yeah, I was just kind of under the impression that it was just done automatically. Yeah.
No, that's what happens when you represent yourself. You need to, I have to treat you as if you're an attorney. And so I'm assuming that you do know all of the requisites. You're saying yes, and she's saying no. She wants those child support payments deducted automatically. And the way you have it here, it's not going to be done automatically because the order says that you're suspending that income withholding.
Okay, understood.
So what you're gonna have to do is you can file a new divorce decree, and you do not check that box off. Okay? Now, the other thing that I noticed on your divorce decree is that you all are agreeing for Ms. Carrasco to be the sole managing conservator. Now, you need to know that what a sole manager conservator has is rights, because usually the presumption by the family code is that you're joint managing conservators. Okay, so that's another thing you need to discuss. And then you have stated that you're going to have standard possession, that it should be attached as Exhibit A, and you have no Exhibit A attached. So you need to do that when you file your new divorce decree. Have you been visiting with your child?
Yes, I have.
Okay. Let me also tell you, on the new updated decree, do not put her entire social security number. Only put the last 4 digits. Just so that you protect yourselves. Okay?
Yes, miss.
Okay. So just do those little bit of updates, and I'll have you come back. I'm going to give you some time, and I'll have you come back on August the 25th as well.
Okay.
So you all have to re-sign them, okay?
Okay.
All right. Thank you.
Okay.
May we be dismissed?
Yes, you may.
Thank you.
Okay, thank you. Okay, Mr. Ortiz, what case do you have, sir?
Hi, it's CL 210470I.
Okay, CL 210470-I, Capital One Bank versus Gabino Ortiz. This is a hearing on a motion for default judgment. Do I have anyone here on behalf of Capital One? Capital One Bank, okay. No one being here from Capital One, then their motion for default judgment will be denied.
Thank you, Your Honor.
Okay, so Mr. Ortiz, the only thing that you're gonna be, have to do if you're gonna represent yourself is you do have to file an order denying the motion for default judgment. Now, did you happen to get a copy of the order granting the default judgment? When they sent you the motion for default judgment, did they send you an order granting?
No.
Okay. Unfortunately, I can't tell you how to draft that, but maybe you can ask for a little bit of help. I'm not sure from whom. I can't tell you who.
I got
I'm
Google
gonna,
and YouTube, so.
okay. So just file an order denying. If you don't
Okay.
have the electronic filing, you need to get that filed in person with the clerk's office, okay? And that'll be with the Hidalgo County Clerk's Office. And I'm gonna give you some time to do that. So I'm gonna set a tickler for August the 27th, just to make sure that you've done the order denying.
Got it.
Now, if they file an order resetting hearing for whatever reason, they'll go ahead and send you notice for that, okay?
Okay, Judge. Thank you.
Okay, we'll see you then.
Thank you. I appreciate
Okay.
that. Have a good day.
Thank you, likewise. Okay, Julie's iPhone, what case do you have?
Hello?
Hi.
Hello, yes, I do have case number 151520-9.
Okay, in the matter of the marriage of Oneida Juliana Hernandez and Ruben Hugo Hernandez Flores.
Yes.
And are you still pro se?
Excuse me?
You're still pro se? You're still representing yourself?
Yes.
Okay, one moment.
And sorry about the Julie iPhone. I tried to put my name on it, but I just couldn't.
Okay, so you filed a motion for a substitute, I'm sorry, a motion for citation of publication?
Yes.
Okay, one moment. Okay, so you attempted to have him served in person?
Well, not in person. I was trying to do it by publication or anything like that because the last known address that I had was from him was in Mexico. I did send him long time ago, like over a year, so he can sign the papers, but it was returned back to me.
Okay.
So maybe
So-
he was now no longer that address.
Okay, the problem is that since the last known address that you have for him is in Mexico, you are going to have to find a way to do that citation in Mexico. And the way that you do that is through the consulate's office. So I think this is getting to be over your head as to how to do it on your own.
Yes, because I've been doing this since April.
Yes.
Over a year.
And I understand, but because the last known address you have is in Mexico, there are certain procedures that you have to do. So what I would suggest is see if you can get some funds together and look for an attorney that can help you with doing the service through the Mexican consulate. Because if not, you won't be able to proceed forward.
Okay. So, but if I can't find them or anything like that, is there something that I can do?
Yes, no, you probably won't find him. The reality is that you probably won't find him. But if you go through service through the Mexican consulate and that process, you will satisfy the requirements of the Texas Rules of Civil Procedure. And then you can move forward.
Okay.
You know what I mean?
Yes.
But you have to do that first. And I just, I don't know that you would know how to do that as a pro se person.
Yes.
So you're going to need to get somebody to help you.
Mm-hmm.
I mean, I'll grant, I can't grant you the citation by publication because you have no publication to put it in.
Yeah.
You understand what I'm saying?
Yeah. Uh-huh.
What I can do is give you an opportunity to have somebody hired so that they can explain to you how they can get the service through the Mexican consulate. That's the best, you know what I'm saying?
Yes.
Because service by citation by publication is reserved for when the person is living in a certain area. Like if you knew that he was living in Hidalgo County, you could do it by, posting it on the courthouse wall. You can do it by posting it in a newspaper, but you don't. Or if he was in another county in the United States, anywhere in the United States, you could do a service by publication by publicly publishing it in their publication of the city of where he's at. But you don't know. The last information you have tells you that he's in Mexico. Which means that you have to go through those hoops through the Mexican consulate.
Yes.
So there's not much I can do about it.
Okay, so I would just have to hire then an attorney so I can get that help when.
Yeah, and what I'm going to do is I'm going to set you for a status hearing because I can't hear your motion for citation for publication because there's nowhere for you to publish it.
Yeah.
Okay. But I will hear you for a status and give you some time to hire somebody. So just so that I don't lose you, because I know you've been trying to get divorced for a while.
Yes, and well, like I said, that's the only thing that I know. I mean, but I'm just like, I don't know where he's at. That's the point.
Right. I understand.
Don't know where, I don't know if he came back or, I just really don't. No communication since he just abandoned the house. He just left.
Well, if you get some evidence that he's actually in a certain location, you can file an order resetting hearing for your motion for citation by publication, because you will need to update your affidavit to indicate where it is that his updated information leads you to believe that he's living. Okay. But if not, I'm going to set you for a status just so that we don't lose you.
Okay.
And so I'll have you come back on September the 8th at 9:30.
Okay.
And I know that you've been very patient and I did see you in your work clothes and all that stuff, but just for future, you're not allowed to be on camera with that workout clothes, okay? So
yes.
Next time, it's a mistake. I understand you're probably trying to get to your next step in the day, but next time you have to be fully clothed, okay?
Yes.
Okay, so we'll see you back here for a status hearing on September the 8th at 9:30.
Okay.
Okay.
Thank you.
All right, thank you. Okay, so did anybody call in on number 22?
No, ma'am.
I don't believe so, Judge. Let me just make sure they didn't file anything last minute.
Okay.
No, Judge, no, nothing was filed.
Okay, then go ahead and set it up for a DWAP. Okay, and how about number 24? Anybody call in on that?
No, ma'am.
Okay, did he provide an email address for the link?
Yes, Judge, and it was sent to Rene Arcuate30@gmail, which is his first and last name, 30@gmail.
Okay, so he applied for this pro se and nobody appeared, so just set it for a DWAP.
Yes, ma'am.
Okay, and number 27? CO 182351-I, Bank of America versus John White. Did anybody call in on that?
No, Judge.
Okay, then just set that for a DWAP. And then F 5113-13-9 in the matter of the marriage of Mara Resendez versus Andres Alvarez. I know that the attorney tried getting on and off. Why did we carry it over on this from May? Was it no appearance? Okay, then set it for a DWAP. Okay.